well. So welcome to today's webinar on evictions during the COVID-19 pandemic. This is the third webinar that LegalARTLink is presenting related to COVID-19 issues, and the first two can be found on our YouTube page. My name is Allyn Ayers. I'm an attorney, and I'm the LegalARTLink director at Locust Projects. Just a bit of housekeeping before we get started. Please stay muted in order to minimize the background noise during the presentation. In the interest of time, I won't be taking live questions, but I will be monitoring the chat. So if you have a question or if something is unclear, please feel free to drop it in the chat, and there will also be time for a Q&A at the end. Also throughout this presentation, I'll be pasting some links into the chat. I don't believe that there's a way to access the chat box after the meeting ends. So if you're interested in visiting those links today, please make sure that you save them somewhere on your own computer or device. Otherwise, we will try to make this PowerPoint available on the LegalARTLink page on the Locust Project's website, and the links are included in here as well. I'll just start with a little bit of information about the LegalARTLink program in case you're unfamiliar. The LegalARTLink program is provided under the umbrella of Locust Project's offerings and aims to empower artists by providing legal information and advice for specific issues, and by educating artists and empowering them to take control of their careers. Normally, we offer legal assistance to members of Locust Projects. However, in order to support the community during this public health and economic crisis, we are waiving that membership fee to access LegalARTLink. So if you have a specific legal issue and you need assistance, please don't hesitate to visit our website, which is locustprojects.org, and navigate to the LegalARTLink page where you can submit your issue. I'll also paste into the chat my email as well as a direct link to our artist form where you can submit any issue. And the final point of housekeeping, because this is a legal presentation, it does come with a disclaimer. So I'm just going to go ahead and read that for you here. So the information and materials that we're providing during this webinar are for informational purposes only. They're not intended to provide a legal opinion or to constitute legal advice, which must be tailored to the facts of a particular situation. Due to the novelty of the situation and the rapid changes to public health policy at the local, state, and national levels, the information provided during this webinar may not contain the most up-to-date legal or other information. Use of and access to this webinar does not create an attorney-client relationship between you and the provider. You should consult an attorney for legal advice relating to any particular issue or problem. Okay. So we can go ahead and get started with the substance of this presentation. So this presentation is aimed mostly at providing information for residential tenants who are or who may become at risk of eviction. However, if you're a commercial tenant or a landlord and you have questions about your rights under the current regulations and emergency orders, please feel free to contact me by email, which I put into the chat, or you can fill out that artist form, which is also linked in the chat. So we're going to start with going over the evictions process and what that looks like under the normal guidelines. We'll next look at the current expiring and expired emergency orders and policies relating to evictions that have been passed at the national, state, and local levels. So at the federal level, we have the CARES Act, Florida-wide. Both Governor DeSantis' office and the Supreme Court have issued emergency orders relating to evictions. And at the local level, we'll look and see what the courts and the Miami-Dade Police Department are doing with respect to evictions. And then I'll conclude the presentation with some rent relief programs and available options that exist right now. As a bit of background on the current situation, as you know, COVID-19 has led to widespread unemployment and has put tenants in a difficult situation. Unemployment claims have exceeded 1 million applications for at least 17 weeks now, and the arts and creative fields have been especially hard hit by unemployment. While the CARES Act supplemented unemployment benefits with an additional $600 per week, that benefit is set to expire by July 31st unless Congress extends it. Many tenants who have lost income due to the pandemic have already had trouble paying their rent. So with the supplementary benefit expiring, the risk that tenants face increases dramatically. Mass evictions are expected at a nationwide level. Some estimates place as many as 1 in 5 American renters at the risk of eviction. In Florida alone, as of July 1st, there were already over 2,600 eviction lawsuits pending in the courts. And the Sun Sentinel reported that 1 in 3 adults in Florida said that they missed their June rent or wouldn't be able to pay July. As a short-term measure, or in response to this, the federal government, Florida, and local governing bodies have implemented temporary halts at different stages in the evictions process. However, these are generally without rent relief, which means that tenants are still obligated to make their rental payments and arrears will still accrue. So this just halts the ability of the landlord to evict the tenant, but it doesn't provide any relief as to whether rent becomes due. So we'll be going over these temporary measures, but I wanted to give an overview of the evictions process first, so that we can understand better how the emergency orders apply to the different stages. So in Florida, evictions are governed by the Florida Residential Landlord and Tenant Act, which is Florida Statutes Chapter 83, Part 2. And I am pasting a link to the full text of that statute in the chat. It's also linked here in the presentation, which we'll make available. So this law sets forth the rules and procedures that landlords must follow in order to lawfully remove a tenant from property. They must follow the process, file a lawsuit, and obtain a judgment in order to evict a tenant. There's no self-help eviction allowed. This means that a landlord cannot attempt to force out a tenant of the property without a court order by doing things like changing the locks, shutting off utilities, or removing tenants' property. If a landlord does this, they can be liable for the greater amount of actual damages, so the actual cost that they caused their tenant by doing these things, or 3 times the rent. So if you run into an instance where your landlord is trying to get you out of the property without going through the proper evictions process, you should contact LegalARTLink or another attorney immediately to help with that situation. So now I'll go through what an eviction looks like under normal circumstances, not subject to the COVID-19 situation. So there are many reasons why a tenant might get evicted. The most common of these are failure to pay rent, holding over after the lease ends, or failure to vacate. So if the lease ends at the end of July and the tenant remains into August, they can be liable for double rent for that time that they're staying in the property without surrendering it at the end of their lease, and also by breaching a term of the lease agreement. So we'll go into greater detail about the process of the evictions now. So before your landlord can file a complaint for eviction, which initiates the lawsuit, they must give you notice. And that notice must follow the form that's prescribed in the Landlord Tenant Act. If the eviction is for non-payment of rent, the landlord is required to give the tenant 3 days notice to pay, and the notice should state the amount that's due. This 3 days does not include the date the tenant receives the notice, and it doesn't include Saturdays, Sundays, or legal holidays. So when you're counting, you count from the date you receive and then 3 days forward without including any weekends or holidays that might fall within that time frame. If the landlord accepts a partial payment in response, they must either give you a receipt for your partial payment and state the remaining balance due. They can place that partial payment in the court registry when they file the lawsuit, so they can't pocket it and then file a lawsuit without also having a new 3-day notice that shows the new balance. After that 3-day period, if the tenant does not pay the rent that is due, the landlord can file a lawsuit in county court. The court will issue the landlord a summons, and the landlord can use the sheriff or a private process server to serve the complaint on the tenant. After the tenant is served, they have 5 days, again, not counting holidays or weekends, to answer the complaint. Delivery. In order to defend an eviction action, the tenant must file an answer, and they have to, Florida law says that the tenant has to pay the rent due into the court registry or ask the judge to determine how much rent is due by filing a motion to determine rent. And you should do that if you think that the amount that the landlord indicated in the notice or the complaint is incorrect. Of note here, the landlord is only allowed to demand the rent. So if the amount that they put in the notice or in the complaint includes any other fees that are not rent, such as late fees or other charges, then you can file this motion and ask the judge to determine how much rent is due. Unfortunately, if you do not answer the complaint and you do not deposit the rent that's due into the court registry or file a motion to determine rent, then you waive all defenses and the landlord is entitled to judgment, which means they'll be able to evict the tenant from the property. If you do defend the case, it will likely be set for mediation, where a mediator will try to reach a solution between you and the landlord. And if that doesn't resolve the issue, you'll have a hearing or a trial. Once there is a judgment in the landlord's favor, the clerk of the court will issue a writ of possession, which entitles the landlord to legally regain the property. The sheriff's office enforces the writ of possession by posting it on the property and then giving the tenant 24 hours to vacate. After that 24 hours, the sheriff can return and the landlord can change the locks and remove your property. In Miami, this usually takes longer than 24 hours, but tenants shouldn't rely on that fact. So the writ of possession gets issued after the judgment, and then that's enforced by with the help of the sheriff's office. And I just wanted to list here some common defenses in the evictions process in case they might apply. However, remember that in order to raise these, the rental amount due does have to be deposited into the court registry. So that means if your landlord says you owe back rent of $2,000 and you think that the landlord is evicting you for example, a retaliatory reason, you have to put that $2,000 in the court registry. And in order to raise that retaliation issue. So these defenses may not be available due to the financial restraints of this COVID emergency if that prerequisite isn't able to be met. So one defense that a tenant could raise is that the notice was defective, but landlords are given an opportunity to cure that 3-day notice to bring it in line with what the statute says it has to include. Waiver by accepting rent with knowledge of non-compliance, and that's for if the eviction is for a breach of the lease agreement or a non-compliance with the lease agreement, that the amount of the rent in the notice was incorrect, and again to raise that, you would file a motion to determine rent, that the eviction is retaliatory, and the landlord failed to maintain the property. So that's how how the eviction process works under normal procedures. So now we'll take a look at the emergency procedures. that have been implemented, and then take a look at how that affects the evictions process. So as I mentioned before, federal, state, and local governments have implemented procedures to stop evictions temporarily during the height of the pandemic. At the federal level, the CARES Act provides a limited moratorium. There's also a limited moratorium in Florida by order of the governor. And the Supreme Court previously put up a roadblock vote. It looks like that roadblock has been now taken down. In addition, local policies are also halting some of the stages of eviction. So we'll first look at the CARES Act moratorium. The CARES Act created a limited moratorium that applies to an estimated 28% of American rental units. For covered properties, it created a 100-day moratorium period that started on March 27th when the act was passed, that prevents eviction and precludes imposing fees, penalties, or late charges during that period. Under the CARES Act, a landlord may not even issue a notice during the moratorium periods. This means that for CARES Act properties, a landlord cannot give the 3-day notice that is a prerequisite to filing for eviction in Florida. Moreover, after the moratorium period ends, that notice must be for 30 days rather than 3. It does not apply to all leases, but only to those that involve covered properties under the Act. In general, these covered properties means properties under federal housing programs like affordable housing, HUD, VA programs, and other low-income housing programs. Buildings where at least one tenant in the building has a Section 8 voucher, or where the property is subject to a federally backed mortgage. On the next slide, I'll give you some resources as well as paste them into the chat that can help you find out if your rental unit is covered by the CARES Act. This does not apply to evictions that were filed before March 27th when the law was enacted. And importantly, the protections are set to expire July 25th, which is this Saturday. There's proposed legislation that would extend and or expand these protections, but it's uncertain if any action will be taken before this ends on Saturday. So again, here are the types of properties that are covered by the CARES Act. So federal housing programs, the property has a federally backed mortgage loan, or at least one tenant in the building has a Section 8 voucher. And they're listed are 2 websites that can help you find out if your rental unit is covered by the CARES Act. But unfortunately, these resources that was the passing, yeah. Unfortunately, these resources don't have every property that is covered, but it is a good start. So let me just get the right links in there. And then we can go on, there we go. And then we can go on to the state protections. Okay, so there were 2 statewide orders in effect. One was issued by Governor DeSantis, who's the executive head of Florida, and one was issued by the Florida State Supreme Court that related to a step in the evictions process. I'm going to start with the Supreme Court order just because it was recently, they recently changed it so it no longer applies, but I do want to show how it applied before. So in response to Governor DeSantis's initial order, which we'll cover next, the Florida Supreme Court, as part of its emergency procedures issued on April 6th, suspended the statutory requirement that clerks issue a writ of possession after a judgment in an evictions case, which, if you recall, that's the final step in the evictions process of the court before the sheriff can come and assist the landlord with actually removing the tenant from the property. The initial order was of an indefinite duration, so it was sort of, it just said the requirement is suspended, and it was extended several times before it set an end date of June 30th, on which it actually expired. So now it looks like if an evictions case is able to proceed to judgment, and we'll talk about why cases are currently not moving very quickly in that direction, it looks like clerks will now be able to issue writs of possession. So they'll be able to make it to at least that stage in the process. So again, I've linked in the presentation, and I am copying into the chat a link to the Florida Supreme Court orders. My copy and paste is not complying with me very well. So I'm gonna skip this one just because it doesn't apply anymore, but I'll try to figure out how to copy better into the chat. Okay, so we'll move on to Governor DeSantis's order. So Governor DeSantis issued Executive Order 2094 on April 2nd, which, among other things, suspended evictions of residential tenants, but solely for the reason of non-payment of rent and solely due to COVID-19. So it's important to note that this moratorium is limited to non-payment evictions. And if your landlord can somehow prove that the eviction was not, or that the non-payment of rent was not due to the COVID emergency, they could, in theory, pursue that eviction as well. But they could, landlords can pursue evictions for reasons that are not related to the non-payment of rent. So for example, we talked about holdover tenancies before. So if you stay longer than your lease, then it looks like those cases are moving forward in the courts at this time. And the order also clarifies that it does not affect the tenant's obligation to pay rent, which is still owed and becomes due over the course of the order. The initial order was for 45 days, and it has been extended several times. The last two extensions came within 24 hours of when it was set to expire. The most recent extension was ordered at 8 p.m. when the order was set to expire at midnight that night. So it was very close to the end of when that moratorium was set to expire. And that current order is in place until 12:01 a.m. on August 1st, so the end of this month. It's possible that it could be extended again, but again, that extension could come like the last one did at the midnight hour or close to it. So next we'll look at what's happening at the local level and we'll start with the courts. So in order to ensure compliance with the CARES Act, which again halts evictions and creates that longer notice period, courts are requiring that landlords in evictions case file an affidavit. So they have to state whether their property is covered by the CARES Act or not. They don't need to file it when they file their complaint, but they must do so before they can have a judgment. We surveyed the evictions docket, and it looks like right now, once an eviction is filed, summonses are only being issued for commercial evictions and for residential evictions where the reason for eviction was something other than non-payment of rent. For evictions based solely on non-payment, there's generally just the complaint on the docket, even for cases that were filed several months ago. Besides that, we're seeing little other movement on evictions cases that have already been filed in court. So it looks like for some cases, they're issuing summons so that the defendant can be served, but we're not seeing a lot of hearings or mediations set in these cases. So it's unclear how judges are prioritizing these with their other cases that are piling up. And again, it's expected that evictions cases are going to be very high in terms of the amount that are filed. So it's possible that they could take longer to go through the courts than they normally would once they're allowed to proceed. Next, we'll look at what's happening in the Miami-Dade Police Department. So this screen grab was from yesterday, but I did check this afternoon and it is still current. In March, the Miami-Dade Police Department announced that it was suspending eviction activities until further notice. That's still the case as of the case that involved the summons when issued the summons and is filed with the case for they will serve it on the tenant. It can also be done by a private service company in cases where summons have been issued. And they are also involved at the final stage, enforcing the writ of possession. So until the police department resumes eviction activity, even if a landlord makes it all the way through the court process and obtains that writ of possession, they're not going to be able to enforce it without the police department assisting them. So unfortunately, there's not a lot of information about when the police department plans on resuming these eviction activities, but we know that until they do so, the last Is this better, Alex? Okay, great. I think I switched out my AirPod to the other ear. So I'm gonna go back and cover this one again, just in case you didn't catch that. So again, this is what the Miami-Dade Police Department is doing. The screen grab is from yesterday. In March, the police department did say that they were pausing or suspending eviction activities until further notice. For the police department, this means two things. They're not going to serve the summons on the tenant, and they're not going to enforce the writ of possession. So until the Miami-Dade Police Department resumes these activities, even if the landlord makes it all the way through, gets a judgment, gets rid of possession, they're not going to be able to remove the tenant without the police department enforcing that writ of possession. And we don't know, there's not really any guidance on when that's going to happen. So again, here's that evictions process, and I just want to show how these measures affect this process as it currently stands. So if it's CARES Act property, they can't even serve the notice. At this time, the clerk in Miami-Dade County is not issuing summonses for non-payment cases, and the Miami-Dade Police Department is not serving process on the defendants. However, again, if it's not a case for solely non-payment of a residential tenant, so if it's a commercial eviction or for another reason, it looks like the clerk is issuing summonses and the landlord can hire a private service company to serve on the tenant. The governor's order prevents evictions for non-payment. So those cases just aren't moving forward even if they do get filed. It doesn't look like there's a lot of movement on residential evictions for non-payment or even on it doesn't look like there's a lot of movement in the courts. I believe my AirPod just died. Can someone let me know if you can still hear me? Okay, I hope you can still hear me. Great. Okay. And then finally, the
the Miami-Dade Police Department is not engaging in eviction activities. So that final step, the actual eviction by the sheriff, won't be able to take place. So that's sort of how this stands. Again, it's not really one stop to the process. There's a bunch of different orders that are sort of working together to put up roadblocks, and it's unclear how long they all will last in relation to another. A lot of them are relying on what the others are doing, but this is how it stands right now. So I do want to highlight some rental assistance resources that might be able to help some folks with this rental issue. The first is a statewide program that's provided for through the CARES Act. And there's not a lot of information on this available yet, but essentially Governor DeSantis authorized $120 million to be administered through local state housing initiatives or SHIP programs. The program is intended to assist with monthly rent and mortgage payments and emergency repairs through December 30th of this year. And the amount that tenants will receive will be determined by the local SHIP office. Applicants must meet an income requirement of less than 120% of the area median income. So for Miami-Dade, that starts at $76,800 for a single person household and goes up from there. And I'll link the guidelines on the next slide and in the chat. Okay, so here's some links on the statewide rental assistance program. The first link goes to the main page. The second one shows the chart for income eligibility, and then there's an FAQ sheet. The call line just opened up July 20th, and that's available Monday through Friday, 9 a.m. to 7 p.m. And they might have more information on what this program will look like when it's rolled out. It's not quite rolled out yet, but they said it should, within the next month or two, there should be more information. And then Miami-Dade also has a county-wide emergency rental assistance program, which provides a one-time benefit intended to assist with 1 month of rent. The amount of the benefit is subject to caps. So the amount will be the lesser of these caps. And just to give you an idea what the caps are for a studio, it's $1,280 for a 1-bedroom. It's $1,372 for a 2-bedroom, $1,646. So those are about where the caps are. So the payment is for the lesser of that number or your actual rent minus 30% of your household income. So they'll give you the lesser of those two numbers. For this program, you have to be under 80% of the county area median income, which starts at $51,200 for a single person household. And you can't be receiving other benefits like the Section 8 voucher, public housing, VA benefits, etc. You must be able to document financial hardship through showing a loss of employment or that you're receiving unemployment or other ways that you can document hardship due to COVID-19. And under this program, the payment is sent directly to the landlord. That application is due this Friday at 5 p.m. And the program is capped at $10 million. I think they're expecting that more applicants will apply, then they'll be able to distribute the funds. So the applicants will be randomly selected up to the $10 million that's allocated. If you want to find out if you qualify or to apply, again, that deadline is coming up. It's this Friday at 5. These are some places where you can get some information about that. And again, I'm putting them into the chat. Finally, I just wanted to include some great websites that have other resources and guides and up-to-date information on how these different orders are affecting the evictions process in Florida and elsewhere in the country, as well as providing resources like sample answers and ways that you can try to defend an eviction if you get that notice. So yeah, that's the end of my presentation as far as what were the current orders and how they affect the evictions process here in Florida. But if there's any questions that participants have, I'm happy to answer those now, either in the chat or over the audio. And again, we'll try to make this both the video and the PowerPoint available within the next few days so that these resources will be accessible on our website. However, if you, again, if there is one link I would copy right now, it's that application to the countywide rental assistance program, because again, that deadline is coming up quickly. All right, if there's no other questions, I think we're gonna go ahead and end it there. Again, we hope to make this available on our website and YouTube page as we've had the other webinars. If you have any other questions about evictions or any other legal issue, COVID or non-COVID related, please feel free to email me. My email is up on that screen now. Or again, you can fill out our artist form directly. We're here to assist throughout this difficult time with this issue and any others that may come up. Thanks for joining us this afternoon.